a fine Wednesday morning, March 18th, 2009. And, I just want to let everybody know that I was, deprived of justice when I went to court because, it was actually involving matrimonial property, and Justice Horner's judgment yielded my ex-wife more than 94.5% of matrimonial property in her favor, and I received like less than 5.5% of matrimonial property of all equity. And that's from a marriage and a separation with 0 exemptions. And that date is actually based on separation date. And then I was abandoned by my wife because I couldn't walk. I have MS, and I guess everybody has the right. If you have a husband or wife that's gets in a car accident or becomes disabled, and I became disabled because I do have MS, and I couldn't walk. I had poor lateral balance, and anyways, I live every day of my life like a horse kicked me in the left side of my head. And because I woke up a Remembrance Day of November 11th in 1998, and I'm like, whoa, I had I had brain damage, left side of my head. I later went for an MRI scan, and the MRI scan showed lesions all the way in the left side of my head, all the way deep down into my brain. And so as a result of having MS attack, it's left brain damage, and have short-term and cognitive problems. But my long-term memory is well intact, and I don't forget about a thing. It's when I have conversations with people. That's where, I have a hard time having conversations with people because I'll forget about, the conversation. But whatever I forgot about, I'll remember. I'll say, oh, I forgot about that. I'll remember it the next day. And when I'm well versed in something, I can do really good. And the thing is, like the law at trial, I was deprived of section 6, 6.2, 28.1, and 28.2 of the Canada Evidence Act C5, and that's actually the whole act right there. Well, just parts of the act of the Canada Evidence Act, and like the thing is. Section 6.1 of the Canada Evidence Act states that a witness that has difficulty communicating by reason of physical disability, the court may order the witness to be permitted to give evidence by means of reason that enables evidence to be intelligible. And Section 6.2 states evidence. This is like evidence with a person with a mental disability. Because I do have MS, I do have a mental disability where I have those cognitive problems and short-term memory. So I have to have things filed into my long-term memory so I can be well versed on it. And Section 6.2 states if a witness with a mental disability is determined under Section 16 to have the capacity to give evidence and has difficulty communicating by reason of a disability, the court may order that the witness be permitted to give evidence by any means that enables the evidence to be intelligible. So really, when I was ambushed with evidence, you cannot. So that's why I was ambushed with evidence right in the middle of the trial, and I'll be posting the whole conversation. Well, the court proceedings, because I've got the audios, on their way because. Alberta Justice, they deleted like major segments of verbatim that went missing off of my transcript, and on top of being deprived Section 6.1 and 6.2 of the Canada Evidence Act, I was also deprived Sections 28.1 and 28.2 of the Canada Evidence Act. 28.1 reads, no copy or any book or document shall be admitted into evidence under the authority of Sections 23, 24, 25, 27 on any trial unless the party intended to provide the copy has before the trial any copy before the trial given to the party against whom the intended to be proceeded reasonable notice of that intention. But I do actually have the candidate evidence actually posted on my main page, and if you want, you can read it. And this is like a basic law that's in every country in the world, where you can't be ambushed with evidence that that you know nothing about. Everybody has a right to know exactly what they're going to be marched up to the witness box, or I guess in the States they call it the witness stand. Well, here in Canada it's called the witness box. And so Section 28(2) states not less than 7 days. The responsibleness of a notice referred to in subsection 1 shall be determined by the court or a judge or other person presiding, but the notice shall not in any case be less than 7 days. So the thing is, my ex-wife ambushed me with evidence inside the court, and the only way it could have been served to me is actually 7 days prior to trial. And so the Canada Evidence Act is an act, like it states right in the act, it's an act respecting witnesses and evidence. The thing is, so it's not me. I'm not supposed to respect my wife when I'm being cross-examined on evidence, and the judge is supposed to respect me. So when I'm the witness, I'm supposed to be respected, and the evidence is supposed to be respected. And she could have only served her evidence to me 7 days. You can't ambush a person through trial. So what Justice Horner did, I even requested, can I actually see this before I get marched to the witness box? And I was attacked. I was marched to the witness box without even being able to view the new exhibits, with evidence. And so anyways, there is also a rule here in Alberta. It's called the Alberta Rule Court 158.5E, subsection, no, it's actually 158.5, subsection 1E, which means that you can actually adduce evidence into the middle of trial or at a trial, but what that rule states that it would have had to actually been produced into the action or into the case prior to, when the case, but by the time the case started, by the time you serve your notice of claim and the trial, it would have actually had to been produced properly into the action. And I was actually ambushed with emails, 2-year-old emails that I sent to my ex-wife that I knew nothing about. And on the transcripts, it shows that I was baffled, totally baffled, and I've still had to answer questions to it. And I'm gonna have those audios. They're gonna be on their way. I will have them here next week, and you'll hear that. You'll hear Justice Horner and how I was ambushed. And I shouldn't have been ambushed with evidence that I received, at trial. And anyways, so what I'm going to do now is I'm actually trying to get, Justice Horner's judgment yielded my ex 95% of matrimonial equity and property based on separation date from a marriage separation that had 0 exemptions. So if there's 0 exemptions, the judgment should have been both parties get equal 50-50. I paid for half. I paid for the mortgage on the house. I built the garage, and her and her new husband, Virgil Sails, takes it. And anyways, so what I'm going to do is I'm going to call that lady up, the Justice Minister and Attorney General of Alberta, because she is the lady that's supposed to actually, make a request to the Canadian Judicial Council to do an inquiry which may lead to an investigation. But the investigation that I have is about judges committing fraud, because Justice Horner, she ambushed me with evidence, or my ex-wife ambushed me with evidence, and then and she didn't she deprived me of justice pursuant to the Canada Evidence Act.